Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with Ms. Nelson and Ms. Higgs, and the prosecutors are represented by Mr. Edwards, Mr. Orman, Ms. Pearson, and Ms. Stitch McGuire. And we are outside the presence of the jury. I have in front of me the last draft of the jury instructions that I emailed the attorneys, so let's make our way through them. I should state for the record that I reviewed the people's standard instructions and the defendant's standard instructions, and so in drafting this set of instructions, I have taken those standard instructions into account. Additionally, I have incorporated the suggestions that were made during our conference on the introductory instructions for Phase 3. I have incorporated those suggestions from that conference that I accepted into these instructions. All right, instruction number 1, and I'm calling it number 1 because it's first in the draft and it starts with members of the jury. Phase 3 of the sentencing hearing has been completed. Do the people have any objection to this instruction, Mr. Edwards?
No, Your Honor.
Does the defense, Ms. Nelson?
Your Honor, we have made a few objections, raised a few concerns about the instruction that was similar to this one that the court gave. I believe it was at the end of Phase 2, and so we would incorporate and maintain those objections. And just to refresh everyone's memory, we
Well, I remember that one of the objections you made with respect to that first instruction in that set in Phase 2 was that there was no reference to the individual reason moral judgment, and that it could be misinterpreted as conveying to the jury that their decisions or its decisions were going to have to be limited to the evidence. And I disagreed with you for the reasons I stated before. Nevertheless, I have modified that second sentence in the first paragraph to specifically refer to reason moral judgment. So it says, you have received all of the evidence that you may properly consider in exercising your individual reason moral judgment to reach your sentencing verdicts.
Yes, Your Honor, and our continuing objection is that the jury's reason moral judgment, the language in the instructions continues to convey to the jury that they have to exercise their morality and their sense of mercy based upon the evidence in the case alone, and that mercy alone and their sense of morality alone is not a sufficient basis to render a life sentence. So our request, we maintain all of the previous arguments we've made on that point, and our request would be to just omit that first paragraph because we don't believe that it's necessary.
All right, I stand by my previous rulings and my previous remarks. What else?
And then on the second page...
And for the record, I think it is necessary because the point is that this is all the evidence that they can consider in exercising their individual reason moral judgments. In other words, they can't rely on outside sources to make decisions in this case. They're not allowed to do that. That's why we have evidence, and that's why we have the proceedings, so that evidence may be introduced. Otherwise, I'm not sure what the point of having evidence is if they can just consider anything from an outside source. So for that reason, I think it is necessary, but otherwise I incorporate my previous rulings and remarks. What's next?
We would make the same objections and arguments with respect to the first bullet point on the second page of that instruction. And I think that this instruction, this bullet point is really, it's covered by other later instructions in a more complete fashion. And it seems it is a bit incomplete in terms of the discussion about the limited purpose and the limiting instructions and whatnot. And our position is that it should just be omitted altogether and addressed by later instructions.
You're talking about the first bullet point, which starts on page 1 of that instruction and goes on to page 2?
My copies show it starting on page 2. It starts, "You must reach your sentencing verdicts based only on the evidence presented during the trial."
Oh, okay, mine starts at the end of page 1, so I'm not sure where that is.
I have both the court's draft from yesterday as well as the draft from this afternoon, and on both of my copies it's starting on the second page.
All right, hold on. Yours is at the bottom of first page as well? Yeah,
That's the way ours printed. I don't know.
but this is the one we gave you this afternoon? Okay, well, that's strange. All right, well, we'll have to be careful when we refer to things. It was the same email that went to both of you, so I'm not sure why it worked out that way, but the same email with the same attachment. For the record, again, I changed this based on the record made in phase 2, and it reads as follows: "You must reach your sentencing verdicts based only on the evidence presented during the trial, the evidence presented during the sentencing hearing, and the instructions provided by the court, which, among other things, inform you that in reaching each sentencing verdict, you must exercise your individual reasoned moral judgment." And that last part is in parentheses, starting with "which, among other things." And again, I did that based on the record that was made by Ms. Nelson in the jury instructions conference in phase 2. But the request is denied. I don't have a concern with respect to that sentence or that paragraph. What else do you have?
That's it with respect to the first instruction, Your Honor.
Okay. The next instruction, the second one in the set, starts with, "You must give thoughtful and thorough consideration to all of the evidence presented in the courtroom during the proceedings." Do the people have an objection to this particular instruction, Mr. Edwards?
No, Your Honor.
Does the defense, Ms. Nelson?
Your Honor, we have a few concerns, objections, and suggestions with respect to this instruction. Our concern with the first sentence is that it's not necessary, and it seems to suggest that the jury can consider all of the evidence without limitation. And in that sense, it does seem to conflict with other instructions. And so we would propose or request omitting that first sentence. That's our first request.
Do the people have a position on that?
We have no objection to that, Judge.
Okay. At the defense's request, I will take it out.
And our request is also to eliminate that second sentence because it is redundant of the, all right, in my copy, it's the bottom of the fourth page of the first instruction.
That's true. Any objection, Mr. Edwards?
No, Your Honor.
All right, that's out as well. What else?
And then our next request would be that somewhere in this instruction, the court just articulate for the jury, just state it plainly. I mean, it's alluding to these important decisions, but just state plainly that perhaps at the end of that, what's now the first sentence, "Each of you must fully appreciate your obligation to carefully and fairly consider the decisions you have been called upon to make in this case concerning the life or death of another human being." I mean, that is in fact what they are deliberating about at this final phase of the sentencing proceeding, and we think it's important to just state that plainly for them and not beat around the bush and allude to it without actually getting that out. So we would request the court add "concerning the life or death of another human being," or perhaps as an alternative, add to the end of the instruction, "Each of you must appreciate that the life of another person rests in your hands," which I think is some language that we proposed in one of our draft instructions.
Mr. Edwards?
Your Honor, those aren't necessary. It's perfectly clear to the jury what they're doing throughout the instructions in the verdict form.
I agree with Mr. Edwards. So those requests are denied. Those may be appropriate for closing argument, but I don't think it's necessary here. I think the point is conveyed clearly. What else, Ms. Nelson, with respect to this instruction? Yes.
Your Honor, Ms. Higgs is pointing out to me that the way it's worded now could be read to imply that their obligation is to carefully and fairly consider all of the decisions that they've already made in the case instead of just the decision they are about to make, this final decision that they are about to make. So we would ask at a minimum the court perhaps amend it to state something like, you must fully appreciate your obligation to carefully and fairly consider the decision you are called upon to make in this final phase of the sentencing proceeding, or something along those lines.
I don't have a problem with that. Do the people object?
No, Your Honor.
Okay, it will say in this final phase of the sentencing hearing. All right, the next instruction starts out with your final sentencing verdicts are not dictated by law. And then it goes from there. Do the people have an objection with respect to this instruction? Mr. Edwards?
No, Your Honor.
Ms. Nelson?
The only thing I feel compelled to make is I believe that this instruction was altered at Mr. Edwards at the prosecution's request in phase 2. That final sentence, in order to reach your sentencing verdicts, each of you will be called upon to deliberate and to make decisions based on your individual reason, moral judgment. I believe we objected to the inclusion of to deliberate and I, excuse me, maintain that objection.
Mr. Edwards?
Your Honor, just as it's important to have individual reasoned moral judgment, it is also important that the jury deliberate.
I agree with that. I think it's an accurate statement, so the request is denied. The next one starts out with, you must now consider whether the defendant should be sentenced to life imprisonment without the possibility of parole or death on each count of murder in the first degree. And then it goes from there. Do the people have objections to this instruction, Mr. Edwards?
Your Honor, the people have no objection.
Ms. Nelson?
We do have a few things, Your Honor. First would be in the third sentence of the first paragraph where it currently states, you and you personally will determine whether the defendant will be sentenced to life imprisonment without the possibility of parole or death on each count. That implies like a group decision in some respect, and we think it's more accurate and compliant with Tennyson and Young and Colorado Constitution, Article 2, Section 20, as well as the 8th Amendment, to state each of you personally will determine whether the defendant will be sentenced to life imprisonment without the possibility of parole. And I would add Caldwell versus Mississippi to that as well.
I think this language comes from your tendered instructions and the people-centered instructions, but I don't have a problem changing you and you personally to each of you personally. Is that what you're asking?
Yes.
Is that okay with you, Mr. Edwards?
That's fine, Judge.
All right. Thank you. What else?
And then the next objection is just an incorporation by reference of the previous objections that we've made to the language in the second paragraph concerning the exercise of your individual reason, moral judgment being based on the evidence and information provided in the courtroom.
All right. My rulings and remarks with respect to that issue stand and are incorporated by reference. What else?
And then the last sentence of that second paragraph, each of the jury's sentencing verdicts must reflect, similar to the change that we just requested to the first paragraph, we think it should read, each juror's decision must reflect a profoundly reasoned moral response.
Mr. Edwards?
We have no objection to that, Judge.
How about if I change it to each juror's sentencing decision must reflect a profoundly reasoned moral response to the defendant's background, character, history, and crimes. Does that take care of it, Ms. Nelson? Each juror's sentencing decision?
Yes,
Okay, what else?
that's it for instruction, the fourth instruction.
All right, the next instruction starts out with, based upon your verdicts at the end of the trial, the defendant has been found guilty of 24 counts of murder in the first degree. And then he goes from there. Let me tell you that I added, the last paragraph is my attempt to avoid a Caldwell type of situation. So that's why that last paragraph is there. All right, with that explanation, do the people have objections to this instruction, Mr. Edwards?
No, Your Honor.
Does the defense, Ms. Nelson?
Yes, sir. First, we would maintain our objection and incorporate by reference the arguments that we made about the issue of merger.
Okay, and I incorporate by reference my rulings and remarks with respect to that issue.
The second request is that the court omit the first part of that second paragraph that discusses the jury's findings in the first phase and the second phase. It doesn't appear to be necessary to remind them of what they've already found. I don't think we did that in the second phase with respect to their first phase findings, and we would request that the paragraph begin during this third and final phase of the sentencing hearing as to each of the 24 counts of murder in the first degree. You must decide whether or not, etc.
Well, I think it puts it in context, and it's consistent with the large poster, the blow-up that was used by Ms. Brady in closing argument in phase 2. But what's the people's position on this?
We agree with the court.
And again, Your Honor, the concern, I think, of reminding them of their earlier decisions is that those decisions, again, should not, do not dictate the result of this third decision that they're being asked to make.
But we've told them that in another instruction, which we specifically said, you're not bound, if you will, by the decisions made in the other two phases. So I like that language because I think it puts it in proper context. So the request is denied. What else do you have?
And then with the final paragraph that the court added, we object to that paragraph. We have some concerns, and I want to make clear that I think that the issues that I'm about to discuss originate from the merger problem that we maintain is unconstitutional and is an issue here. But the last sentence of that paragraph, this is the case even if you impose different sentences on two counts that relate to the same victim, and even if you impose a death sentence on one count related to a victim and do not reach a unanimous final sentencing verdict on the other count related to that sentence will be enforced, period.
But that doesn't address the situation that's more specific, which is what if there's a difference between two counts related to the same victim? So that's what that second sentence goes to. It addresses that. So
and I'm sorry.
No, I think both of them are needed for that reason.
And we think the court, we disagree. We think that's an incorrect statement of the law, that if a jury were to come back with a more lenient sentence and a harsher sentence on the same act, then the defendant, pursuant to the rule of lenity, would receive the less serious sentence.
No,
So
I think that's incorrect. I disagree. I think it's the other way around. So I think the rule of merger would apply, and I think that the more serious sentence would be given effect. In any event, the rationale that you just expressed doesn't make sense with respect to that situation. But then not with the situation related to the first sentence. In other words, if you believe that the law is what you just said it is, then presumably you would object to both sentences in this paragraph, not just the last. I don't understand how it wouldn't apply to the first sentence as well, given the factual record in this case, so.
Well, I'm sorry, I can explain.
I understand your position, but I disagree, so I'm keeping both of those sentences. Is there anything else with respect to this particular instruction?
If I can just explain why I think it's different.
Sure.
If they were to, in a hypothetical world, impose the death penalty with respect to one victim but not another, their decision not to impose the death penalty on victim B would not invalidate the death penalty for victim A. We agree with that. However, if they were to come back with death on, extreme indifference or death on after deliberation murder on one victim and life on the extreme indifference count pertaining to that same victim, that's where I think we would have a serious disagreement and an argument that the rule of lenity should apply, and that that kind of an inconsistent verdict would violate the Eighth Amendment in Article 2, Section 20 of the Colorado Constitution for the death penalty to be imposed, given the inconsistencies and the unreliabilities in that verdict. So that's why I think it's different. And then the other difference with my proposed language is that it's just telling the jurors, you should presume that the sentence will be enforced or that the sentence will be imposed.
I understand, but the request is denied. Again, I'm sticking to what I believe is an accurate statement of the law. Anything else with respect to this particular instruction?
No, Your Honor.
All right, let's go to the next one. The next one starts with, in Phase 3 of the sentencing hearing, there is no burden of proof. Is there an objection from the people, Mr. Edwards?
No objection by the people.
Ms. Nelson, and is there an objection from the defense?
We have two things, Your Honor. The first is maintaining our argument that the prosecution should bear the burden of proof and burden of persuasion at all phases of the sentencing proceeding pursuant to motions, the arguments and authority. The arguments. The first is that we maintain our position that the prosecution should bear the burden of proof as well as the burden of persuasion with respect to all issues at all phases of the sentencing proceeding, pursuant to the arguments and authority cited in motions D-146 and D-147.
All right, based on my rulings in orders D-146 and D-147, that request is denied. I incorporate by reference those rulings, and again, I point out that I am bound by the Colorado Supreme Court's decisions in Dunlap. I think the Colorado Supreme Court has made it clear that there is no burden of proof on either party at this juncture in the proceedings. What else?
And then the second thing, Your Honor, is the last sentence of the instruction is a bit confusing to us, and we would ask that we hashed out some language. I think that conveys or attempts to convey the same concept.
Well, that language appears in a different instruction. It appears in instruction number 2, I believe. Actually, it would be number 4. In the penultimate paragraph, the last sentence reads, "A juror need not be convinced beyond a reasonable doubt that life imprisonment without the possibility of parole is the appropriate sentence in order to make a decision that will result in a sentence of life imprisonment without the possibility of parole." That was the language that you suggested for purposes of the introductory Phase 3 instructions. And so I incorporated that language into this final instruction. I added this sentence here in this other instruction, the burden of proof, because we're talking about the burden of proof. And so I just wanted to make it clear to the jury that this particular burden of proof does not apply to a final sentencing verdict of life imprisonment without the possibility of parole.
And our request would be to replace that last sentence with the sentence that the court just read that we had agreed upon at the prior charging conference, because it's just, the concern is that, again, they never have to affirmatively choose life without parole. It's the default sentence if they have a reasonable doubt about death. And so an individual juror could have a reasonable doubt about the appropriateness of the death penalty, but still not be, in their own minds, affirmatively selecting the sentence of life without parole over death. And I'm concerned that the way that this last sentence is phrased, that it somehow communicates that that life without parole is a similar choice, or that maybe there's some other standard that's like less than beyond a reasonable doubt or something that does apply that we're just not articulating for them, or something along those lines. So that's the basis for my request that the court just replace that sentence with the sentence that that appears in instruction number 4.
Any response from the people?
Your Honor, the sentence as it is currently drafted is consistent with the verdict form. So we would object to any change in that sentence.
And I can tell the court we also have some concerns and objections about the verdict form.
Given that I'm telling them in a separate instruction that a juror need not be convinced beyond a reasonable doubt that life imprisonment without the possibility of parole is the appropriate sentence in order to make a decision that will result in a sentence of life imprisonment without the possibility of parole, I don't see how this sentence is confusing. They can... This is just telling them that that degree of certainty that is required for a death sentence is not required for a life sentence. That's all it is conveying to them. I'm not sure where the confusion, or where you think the confusion lies.
My concern is that by phrasing it in this way, it suggests to them that they have to be affirmatively choosing a life sentence instead of simply not choosing a death sentence, and that there is perhaps some other degree of certainty that they need to have before they return a verdict that results in a life sentence.
I can delete it if you want. Would you prefer that I delete it so as to avoid any confusion? You have the other sentence. I don't think it's worth, or that it's necessary to repeat it. I'm not sure why I would say it twice the same way. So if it's just a matter of saying it the same way twice, I'm inclined to just delete it.
Your Honor, if my choice is to either not have it at all and have nothing in its place, or to have it the way that it is without waiving my objection, I would prefer to have it for the court to keep it in.
Do the people have a preference, Mr. Edwards?
We prefer, doesn't matter to us, Your Honor, it's up to the court. You could leave it in, you could take it out, I don't think it makes a difference.
All right, I'll leave it in, Ms. Nelson. Anything else with respect to that instruction?
No, Your Honor.
All right, next is the reasonable doubt definition. Any objection from the people, Mr. Edwards?
No, Your Honor.
Any objection from the defense, Ms. Nelson? Yes.
The court amended this instruction, bless you. Thank you. Following the resolution of the allocution issue.
Yes.
So we maintain the previous objections that we made with respect to this instruction as it pertains to the decisions that the jury is required to make at phase 3, but we have nothing additional.
All right, and I stand by my rulings and remarks with respect to this issue, and I incorporate them by reference. The next
I'm sorry, Your Honor, I think that there's a colon there that should be deleted, that was maybe left behind from the way that the instruction previously read.
Oh, you're right. Thank you. Thanks for catching that. All right, the next instruction starts with, there's no requirement that you explain or justify to your fellow jurors why your individual reason moral judgment leads you to a particular decision on a count. And then it goes from there. Do the people have objections to this instruction, Mr. Edwards?
People have no objection.
Ms. Nelson, do you have any objections to this instruction?
We do have a few, Your Honor.
Okay.
First, we would maintain our position, and I know that we discussed this previously. The court removed the word articulate at the request of the prosecution, and we would continue to object to that and request that the word articulate be contained in that first sentence.
Okay, and I incorporate by reference my ruling and my remarks with respect to that issue. I continue to believe that it's more appropriate and more accurate to say explain or justify, and as opposed to articulate, explain, or justify.
Our second request is that the court make that first paragraph consistent with the way that, or more consistent, I should say, with the way that it phrased it during the final Phase 2 instructions, which would be to keep the first sentence as is and then say, nor are you required to agree with the determinations, opinions, feelings, or thoughts of other jurors, and then begin the next paragraph. Nevertheless, it is your duty as jurors to consult with one another and to deliberate.
I like the format that I have here better because I think that part about you don't have to agree with the determinations, opinions, feelings, or thoughts of other jurors fits in better with what comes after that, which is it says, but you must deliberate with your fellow jurors, and then it says, after deliberating, if a juror disagrees with the rest of the jurors, that disagreement must be respected by the other jurors and will be respected by the court. So it fits in well with the concept of, look, you don't have to agree with other jurors. What you have to do is deliberate. And now, once you've deliberated, if you at that point disagree, then that disagreement has to be respected by the other jurors in the court. So that's why I have it structured the way it is. And I like it better the way it is.
Our next request then would be to remove, I think, and I understand that there's this concern that we need to explain to them that they're required to deliberate, but I think that our request would be to omit after deliberating in that second sentence because it seems redundant of the first sentence, the end of that first sentence in the second paragraph where it says, you must deliberate with your fellow jurors. So our request would be to start the second sentence if a juror disagrees with the rest of the jurors. I don't think after deliberating is necessary. It doesn't add anything in it, and it may emphasize that too much.
Well, but that may convey the message that if you disagree during deliberations with the rest of the jurors, that disagreement must be respected. And that's not quite accurate. It can't be that, any disagreement, then that's the end of the deliberations. It is that after you've deliberated, if there is disagreement, then that disagreement has to be respected by others and it has to be respected by the court. Do the people have a position on that, Mr. Edwards?
We agree with the court.
All right, and that request is denied as well. What else do you have with respect to this instruction?
And Your Honor, just to make it clear, it's our position that a juror could listen to what the other jurors have to say, but have their mind made up. And so that's what our concern is, that if they're being pushed too much to deliberate, then that interferes with their ability to exercise their individual reasoned moral judgment.
Which is why I can't tell them what deliberations means or what constitutes deliberations. That's up to them. That's why it's necessary to make it clear to them. After deliberations, whatever that may mean, it's up to them. After deliberating, if a juror disagrees with the rest of the jurors, then that disagreement must be respected by other jurors and will be respected by the court. They have to determine what constitutes deliberations and at which point deliberations are done. I can't determine that, and for those reasons, I think it's important to instruct them as indicated in this particular draft.
Your Honor, would you consider changing the word after to during so that it doesn't imply that they have to deliberate first and then at the conclusion of some sort of deliberative process express their disagreement?
No, because I think that is telling them something that may not be accurate. It's up to them to decide at which point they've deliberated and deliberations are done. If I say, look, during deliberations, your disagreement has to be respected by others, then somebody could point to this instruction and say, I'm sorry, I know that we've only been into deliberations 10 seconds, but the judge said during deliberations, if you disagree with me, you have to respect my disagreement. So there are no more deliberations, we're done. I don't think that that's what the law envisions, and I don't think that's what the duty to deliberate envisions either. So that's why I can't say, look, at some point during deliberations, your disagreement has to be respected. The reality is that it's saying the same thing as after your deliberations. It's just that they have to determine at which point they're done deliberating and they've made up their mind, and people have to respect what they said. So.
Well, my next concern with the instruction, or request with the instruction, goes to something the court said just a moment ago, which is that deliberations can mean, you're not telling them what deliberations may consist of.
Right.
And it's the last part of that last sentence where it says, ultimately each of you must decide for yourselves, based on your individual reasoned moral judgment, the appropriate sentence on each count, after considering and discussing with your fellow jurors the evidence and information presented in the proceedings and the court's instructions of law. And so my concern is that there may be a juror who will listen and consider what the other jurors have to say, but I don't think there's any requirement that they have to discuss. Some people, and we talked about this with the jurors in individual voir dire, that some people are more articulate than others, and some people are more talkative than others, and some people prefer to sit back and listen to what other people have to say, and others are more forthcoming with sharing their thoughts and ideas. And so I that's the concern with that last part of that sentence, and I would ask that the court end the instruction after each count, period.
By the way, it doesn't say evidence and information. You may be looking at the wrong draft. It just says evidence.
Probably am. Yes. I'm sorry. I have a bunch of notes that I made on the first set of instructions, and so I'm working off of those. But yes, you're right.
What if we said, do the people have a position on this, Mr. Edwards?
Our position is we have no objection to striking and discussing. So it would read after considering with your fellow jurors. We object to any other change that the defense has made.
And if the court is considering that, or even if the court grants our original request, we would also ask that the court add some of the language contained in our proposed instruction number 108 that states, it conveys the sentiment that jurors don't need to continue deliberating if their mind is made up. So it says, if any juror at any time during the deliberations decides that they are not convinced beyond a reasonable doubt that a death sentence is the appropriate sentence, the jury must end its deliberations and inform the court's bailiff that they have reached a sentencing decision. There is no requirement that a juror who has decided that he or she is not convinced beyond any reasonable doubt, or beyond a reasonable doubt, that death must be the penalty for Mr. Holmes must continue to deliberate. So we would ask that the court add something at the end of that instruction conveying that they don't need to keep deliberating if they've made their sentencing decision.
Mr. Edwards?
Your Honor, we object to that. That's anti-deliberation language. It's saying that the juror can go back in the 10 seconds the court talked about before and said, I'm done, let's go, let's give him life.
But there's this tension that exists between, on the one hand, the fact that each juror has to make an individual reasoned moral determination, and on the other, the fact that they have a duty to deliberate. And that's what this instruction is trying to convey, that both apply, but they both have to coexist. It can't be one and not the other. They have to deliberate, but ultimately they have to make an individual reasoned moral judgment. They have to make an individual reasoned moral judgment, but they have to deliberate. So give me just a moment. What if I changed it to say, ultimately, each of you must decide for yourself, based on your individual reasoned moral judgment, the appropriate sentence on each count after deliberating with your fellow jurors? Do the people have a position on that, Mr. Edwards?
It's fine with people.
Ms. Nelson?
Your Honor, that does not resolve the concerns and objections that we have. It doesn't convey, the problem is, if an individual juror has made up his or her mind, then how are they supposed to know, and when do they know that deliberations are over? There is no requirement that they keep pushing towards unanimity, and I don't think this instruction conveys that clearly enough, and they need to be told that if they've made up their mind after careful consideration, then at that point, it's over.
But again, that feels like the court interfering with what they do in deliberations and what they deem to be deliberations. So it's up to them. So what's your preference, without waiving your objection, between the way it reads now or the proposal, which is to change the part of the sentence that starts with considering, deleting all that and replacing it with deliberating with your fellow jurors? Yes.
Your Honor, we're asking the court to insert some language so that if it's, say, 8 hours into deliberation and there is a single juror that is being pressured by all of the other jurors to keep going or to change their mind, which is unconstitutional and illegal for the other jurors to do that, that juror have some sort of understanding within the context of these instructions what their options are, that they can let the court know, Judge, I've been doing this for 8 hours and these people are pressuring me and forcing me into doing something that's contrary to my individual moral decision-making. And there is no language in any of these instructions that tells the juror we're not saying that these jurors should get in there and 10 seconds later they should make up their mind. But what do you do for the juror who's being pressured and forced and bullied? And where is that language for that juror? Because that language is equally important, Your Honor.
Well, we're telling them that it's an individual reasoned moral determination. Nobody's saying that they have to keep going until they arrive at a unanimous decision. They're being told specifically, hey, once you've deliberated, other people have to agree to respect your choice, your thought, your decisions. So we're telling them that. It's up to them to decide when determinations are over. I don't think it's appropriate for the court to convey to them, hey, by the way, if at some point you just don't feel like deliberating, just say you don't want to deliberate anymore. It's up to them. It may be that someone says, you know what, I think I pretty much have made up my mind. And then someone else says, well, would you be willing to continue to talk about it? Or would you be willing to consider something else? And then they say, okay, yeah, I'll hear you out. I'll hear what else you have to say. That's up to them how deliberations go. I don't want them to think, well, wait a minute, the court said that once, I wanted to stop this, it's over, and so it's over. It seems to me that it's up to them how they do it, as long as they understand, number one, that it's an individual decision, and we're telling them that. But also understand that they have to deliberate. Now, how long deliberations last, how long they go for, that's up to them. What they do in deliberations, that's up to them. And by the way, I think with respect to every single juror, you asked questions along these lines, and every single one of these jurors who's here in this trial committed to you that they would not be bullied and that they would not bully anyone and that they would stick by their decision. So in individual voir dire, that was a set of questions that was asked of every single juror. And every single juror who's here committed that that would not be a concern. They would not bully anyone and they would not be bullied by anyone. And I don't see how this instruction does not properly convey what they need to know, which is on the one hand, there's a duty to deliberate, on the other, it's an individual moral determination. So between the two choices, do you have a preference, Ms. Nelson or Ms. Higgs?
I think they're both problematic, and so we don't express
Okay.
a preference.
All right, I'm going to change it to deliberating with your fellow jurors. All right, the next instruction starts out with, in reaching your sentencing verdicts, you may consider mercy and sympathy for the defendant. Do the people have any objections to this instruction, Mr. Edwards?
No, Your Honor.
All right, Ms. Nelson, do you want to incorporate by reference the record you've made previously with respect to this instruction?
Yes, Your Honor, and we'd again cite to People versus Davis, Gregg versus Georgia, and Barnes versus State.
And none of those cases said that the court should instruct the jury by just saying that they can consider mercy and sympathy in a vacuum, at least not that I'm aware of, and if I'm wrong, defense counsel should point that out to me. I understand that there is discussion in those cases about mercy and sympathy, and I understand that the discussion is in the context of a specific case, not in the context of providing instructions that the court should give the jury. My understanding of the law is that the jury can certainly consider mercy and sympathy, but not in a vacuum. They cannot ignore the evidence presented in the case and just on their own decide arbitrarily, I am going to exercise mercy just because I feel like it, not because of the evidence and not because of anything related to this case, but just because I'm against the death penalty, or I'm in favor of the death penalty, or because I feel like doing it, or for whatever other reason. There has to be some connection to the case. So I incorporate by reference the rulings I have made and the remarks I have made with respect to this particular issue.
And Your Honor, just to make my record clear, it's been a while since I've read the Barnes case, but I do think that case does stand for the proposition that I am arguing.
Barnes, B-A-R-N-E-S? Yes. And what's the site?
I don't have this. I can get the site to the court, but I don't have it immediately handy.
Is that a Colorado case?
No, it's a case from Georgia. The state court decision from Georgia. Oh yes, it's 496 Southeast 2nd 674. A 1998 case from Georgia. My notes say that it states mercy alone is a valid reason not to impose the death penalty, but I can't promise that's a direct quote. I don't recollect offhand what the specific factual circumstances of that case were.
All right, this is a Georgia Supreme Court case from 1998. And I'm just reading this part of it. It says, in Georgia, mitigation evidence that relates to the individual defendant and not the death penalty in general is admissible. For example, evidence that concerns the defendant's guilt or innocence cannot be excluded by the trial court, even though a guilty verdict has already been rendered in the guilt/innocence phase. The defendant's impaired capacity to understand the cruelty of his acts due to depression, poor impulse control, a troubled youth, and drug abuse is relevant at the sentencing phase. It is reversible error to prevent a friend or relative of the defendant from taking the stand and pleading with the jury for mercy. In fact, for the individual defendant is by itself, in fact, mercy for the individual defendant is by itself a valid reason for a jury to decline to impose a death sentence. A jury can withhold the death penalty for any reason or no reason at all. So it was discussing that in the context of evidence having been excluded. It's a case that's not binding on the court. I can tell you that in Colorado, it would be improper for a witness to take the witness stand and plead for mercy on behalf of the defendant and say, please have mercy and don't sentence him to death. I mean, people can present mitigation evidence. They're not allowed to ask or opine for a particular sentence. So then this was, again, a discussion about mercy in general being something that the jury can consider and being something that the jury can base a sentence on. It's not saying that the jury should be instructed that it can rely on mercy alone without any connection to the case in deciding what sentence to impose. Do the people have a position on this, Mr. Edwards?
Your Honor, we believe that the instruction is a correct statement of the law. And also, the court might consider Brown versus California, that it has the instruction, went up to the Supreme Court, mere sympathy, and the whole line of things, with the end of no irrational, arbitrary, emotional response. Well, mere sympathy, it's sympathy, free, floating sympathy without evidence. That's what that instruction concerned when it talked about mere sympathy.
Right, and I come back to the same point every time, which is that if a jury truly can make decisions based on mercy in a vacuum or sympathy in a vacuum alone, then what have we been doing for the past however long we've been here? I mean, we should have just asked them for a decision at the beginning without any evidence. I mean, it has to have some connection to the case, right? It has to have some connection to the evidence. It can't just be, well, here's the evidence. However, you can ignore it and you can exercise mercy separate and apart and independent, separate and apart from the evidence and independent of the evidence. You can just decide on whatever sentence you want without consideration of the evidence. I don't think that's the way it works. I don't think that's the law. I think they can exercise mercy, and I think they bring that with them. And that may include compassion, and it may include sympathy, and may include understanding. They bring all those things with them to court because that's part of who they are. They don't learn that here in the trial. They don't learn about mercy. They bring whatever they have inside them with them here, and they can rely on that mercy. But there has to be some connection. I mean, perhaps it's connected to his youth, or perhaps it's connected to mental illness, but there has to have some kind of connection to the evidence. Otherwise, again, I'm not sure why we take our time in jury selection to ask about biases, and I don't know why we take our time presenting evidence and making decisions about what is admissible and what's not admissible if in the end they can just ignore all of it. So my position stands. Anything else with respect to this instruction? Ms. Nelson.
No, Your Honor.
Next is the instruction that says under Colorado law, when a person is sentenced to life imprisonment without the possibility of parole, it means that the person must spend the rest of his natural life in prison. Any objection to this instruction, Mr. Edwards?
No, Your Honor.
Any objection to this instruction, Ms. Nelson?
We would just ask that the court add the words ever after cannot. So cannot ever apply for parole and cannot ever be paroled. And also ask that the court incorporate the language in our proposed instruction 106 that says, if he receives a life sentence, Mr. Holmes will die in prison.
Mr. Edwards?
We object to that, Judge. Pursuant to California versus Ramos, 463 U.S. 992, 1983 case, and which is repeated and affirmed in Caldwell versus Mississippi, we would, if any language is added to this instruction, the people are going to ask for additional language that says the governor of the state of Colorado has the power to commute, reprieve, or pardon the defendant.
I don't think it's necessary, and I don't think it's appropriate. In terms of the other request, I'm okay with it. Do the people have any objection to that?
Which request, Judge?
Ever, adding ever twice?
That's fine.
Have on that one.
Okay, the next one is, under Colorado law, the manner of enforcing a sentence of death is by the administration of a lethal injection. Any objection from the people, Mr. Edwards?
No, Your Honor, it's required by statute.
Any objection from the defense?
May I have just a moment?
Yes.
Just ask that the court add to the end of that, you must assume that the penalty of death will be carried out if you vote to impose it, consistent with our proposed instruction 107.
Any objection to that?
Your Honor, I don't think it's necessary, but I don't have an objection to that.
I don't think it's necessary either, but I'm okay adding it, so since the defense wants it, I will add it. Give me just a second. Okay. By the way, does the statute use specific language as to the first sentence? I noticed that both of the tendered instructions, and I'm talking about the one that the defense submitted, the one that the people submitted, said under Colorado law, the manner of inflicting a sentence of death. And I changed inflicting to enforcing because I'm not sure that inflicting is as easily understood as enforcing. And I wasn't sure that inflicting was the appropriate term, but if that's the term in the statute, then that's the one that I want to use.
I don't believe it's in 1201. I think it's in another statute, and I'm looking for it now.
Okay.
Eighteen 1.3, 1202. The manner of inflicting the punishment of death shall be by the administration of a lethal injection.
All right, so I'll change it to the manner of inflicting. Okay, thank you. All right, the next instruction starts with, you are instructed that the fact that the prosecution seeks the death penalty in this case is entitled to no weight whatsoever. Any objections to this instruction, Mr. Edwards?
No, Your Honor.
Any objections? Ms. Nelson? The next instruction starts out with, in reaching your final sentencing verdicts, you must treat the defendant as a uniquely individual human being. Any objections, Mr. Edwards?
No, Your Honor.
Any objections, Ms. Nelson?
We maintain the objection that we previously made with respect to the addition of the prosecution language. Other than that, nothing additional.
All right, and I incorporate by reference my rulings and remarks with respect to that issue. I think that if you just say you're not allowed to be influenced by prejudice or bias of any sort against the defendant, someone could infer from that it's okay to be biased or prejudiced against the prosecution, and the reality is that bias or prejudice are not allowed, regardless of which party one may be biased for or against or prejudiced against. So, and same thing with respect to public opinion or community sentiment. All right, the next instruction starts out with, you are instructed that there are two types of aggravation that you may consider in reaching your final sentencing verdicts. I meant to delete the bold font from this one, so you can ignore it. I had it at one point and I had decided to delete it. So do the people have any objection to this instruction? Oh, and before Mr. Edwards speaks, I added a line at the end of the second paragraph based on the discussion that we had during the jury instructions conference for the introductory phase 3 instructions. The defense had made a request to have me clarify that the jury could not consider mitigation for purposes of aggravation because the definition of mitigation also includes a reference to the nature of the crime and the defendant's character, background, and history. And the defense was concerned that the jury might get confused and think that mitigation could be used as evidence of non-statutory aggravating circumstances. So what I came up with was, you are reminded that any fact or circumstance that you determine constitutes mitigation cannot be considered as aggravation or as a reason to decide that a death sentence is the appropriate sentence. Mr. Edwards, do the people have any objections to this instruction?
No, Your Honor.
Ms. Nelson, do you have any objections to this instruction?
We do, Your Honor, and this is sort of a big issue for us. The first concern, or the first objection, we object to the instruction being given, period, at all. And so I'll make that argument first.
We have no objection to it being excluded.
Okay, that makes it easy. All right, I'll take it out without objection.
I do have a related issue with respect to this instruction that I don't want to forget to bring up.
Okay, go ahead.
And it pertains to something that Mr. Edwards said when we were having our charging conference during the initial charging conference for the initial introductory instructions for Phase 3. And that is that the prosecution may argue or seek to argue that the death of a child is non-statutory aggravation, as well as the bombs in the apartment or the explosive devices in the apartment as non-statutory aggravation. My impression was that they may seek to argue that those two things in closing argument. And so I would like to move, or I am moving in limine to preclude them from relying on those two things as any type of non-statutory aggravation or aggravation of any kind at all during closing arguments. The reason is...
Hold on, before you tell me
Okay.
the reason. Mr. Orman, do you know whether Mr. Brockler is intending to do that or not?
Your Honor, I've had some discussions with him about his argument, but I don't know.
Why don't we just reserve it for tomorrow then? And then if Ms. Brady is going to make closings, then she'll be here as well.
Very well.
Okay, let's move on to the next instruction, which starts out with, in Phase 3, you received victim impact evidence, which is evidence of any matters relating to the personal characteristics of the deceased victims and the impact of the crimes of murder in the first degree on each victim's family. This is the instruction that I used in the introductory instructions for phase 3, and it includes the suggestions by the defense that I accepted with respect to those instructions. Mr. Edwards, do you have any objections to this instruction?
No, Your Honor.
Ms. Nelson, do you have any objections to this instruction?
Nothing additional beyond the record that we made at the previous charging conference.
Okay, so Ms. Nelson is standing by her record, and I'm standing by my rulings and remarks, which I incorporate by reference. The next instruction starts out with, in reaching your sentencing verdicts, you may consider evidence relating to the personal characteristics of the defendant and the deceased victims, and then it goes from there. Do the people have any objections to this instruction?
No, Your Honor.
Does the defense, Ms. Nelson?
Your Honor, if I may just have a moment, I'm sorry.
And I think I used this instruction because it was in your tendered instructions or in somebody's tendered instructions. But if you folks don't want it, I'm okay taking it out. So what's your preference?
What if the court just gave the last sentence of that instruction?
You are never permitted to do a comparative judgment between the defendant and the victims?
Yes. And maybe added it to the previous instruction on victim impact?
Do the people have a position on that? If I added it to the last instruction, it would probably have to be a separate paragraph, but because I don't think it would follow the last sentence in that instruction, but it could be its own paragraph.
Your Honor, the purpose of this, and this is language out of pain, and the purpose is, so for example, if you had a murder case where they were seeking the death penalty and the defendant had, I don't know, 1,000 prior convictions and was the worst person you could think of in the world, and the victim was, say, a minister or a priest, that the fact that somebody was in trouble all the time versus the fact that somebody was a priest, you can't compare them as people and say one life is worth more than another life. So I think that that's what Payne was talking about. We don't have any objection if you take this entirely out, if you place this last sentence somewhere else, we don't care.
Okay, so you're okay with me just using the last sentence but moving it to the previous instruction as a separate paragraph?
That's correct.
All right, and Ms. Nelson, that's specifically what you're asking me to do, correct? For the record, the instruction right now, as drafted, reads as follows. In reaching your sentencing verdicts, you may consider evidence relating to the personal characteristics of the defendant and the deceased victims, but you must not use such evidence to make comparative judgments between the defendant and the deceased victims. You are never permitted to do a comparative judgment between the defendant and the victims. Ms. Nelson? Yes.
Yes, our request would be to just add the very last sentence as a second paragraph to the previous instruction and include deceased victims, just so that there's no confusion about the other injured victims in the case.
Okay.
Both.
Okay, the next instruction is the court reminds you that the number of witnesses testifying for or against a certain fact during the proceedings does not by itself prove or disprove that fact. Any objection, Mr. Edwards?
No, Your Honor.
Ms. Nelson?
No, Your Honor.
The next one is about the credibility. It's a credibility instruction. It's the model instruction, but modified slightly to fit this situation. Any objection, Mr. Edwards?
No, Your Honor.
Ms. Nelson?
May I have just a moment, Your Honor? I don't
Yes.
think I realized it had been modified.
Well, I mean, it's been modified so that it says the court reminds you at the beginning.
Oh. Then no, nothing.
Okay. The next one is the one about expert witnesses. It's essentially the model instruction. Any objection, Mr. Edwards?
No, Your Honor.
Ms. Nelson?
No objection.
All right. The next one is the one that talks about evidence admitted for a limited purpose, and the people had submitted a tendered instruction that said that any limitations placed on evidence no longer apply or something along those lines. The defense indicated in one of the documents submitted with its tendered instructions that it believed that was unconstitutional and inaccurate. I think that the limitations continue to apply, and so I drafted this instruction to reflect that, and I drafted it as best I could. Do the people have any objections to this instruction, Mr. Edwards?
No, Your Honor.
All right, Ms. Nelson?
Your Honor, my primary concern with the instruction, we would ask that the court give the instruction that we drafted in our proposed instruction number 101.
What's the difference between yours and mine?
Well, a couple of things. First, I would note, before getting to that there's a reference in this instruction to evidence of non-statutory aggravating circumstances as distinguished from proven statutory aggravating factors, and since the prosecution has agreed not to give that instruction, I don't think we should be injecting that concept.
I
into
agree
this
with you.
instruction.
Give me a moment. Okay, what else?
So the concern is, I can read the language. Why don't I?
Judge, I hate to interrupt, but what change did the court make?
In the first sentence, I took out evidence of non-statutory aggravating circumstances.
Okay, thank you, Judge.
You're welcome. Ms. Nelson?
My concern with the way that the court has phrased this instruction in terms of the evidence admitted during phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor may not be considered as evidence of aggravation or for any other purpose, is that the jury is not precluded during phase 3, during their deliberations or during our argument or anything like that. They're not precluded from finding additional mitigation or considering that mitigation again. And the concern is that the way that it's phrased seems to be suggesting that anything that they, whatever they decided or considered about that evidence in phase 2, sort of the last word on that, and that they can't consider anything for any purpose in phase 3, including mitigation. I mean, they may be reflecting back on the evidence that was presented at trial, and in their own hearts and minds and individual reason, moral judgment, decide that something else that they didn't think of before is mitigating to them at this phase. And so the way that we proposed the instruction read is as follows. In making your decision during phase 3, you may not consider any evidence that was admitted solely for your consideration of the issues raised by Mr. Holmes's plea of not guilty by reason of insanity during the previous phase of this trial, or we could tinker with that language, as a reason to impose the death penalty. And maybe end it there and just say, you may consider this evidence as mitigation or a reason in favor of a life sentence.
I like my instruction a lot better. I think it's much clearer, it's more accurate, and I don't see the concern that somehow that sentence that you just read, or that you read from my draft instruction, can be interpreted to mean you can not consider that evidence for any other mitigation. It's just saying, look, to the extent that that evidence was admitted in phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor, it may not be considered as evidence for any other purpose now, including as evidence of aggravation. So, do the people have a concern with respect to that sentence?
Judge, just as a suggestion that might help the defense, after evidence of aggravation, if the court dropped or for any other purpose, that might solve their problem.
That's really the concerning language to us, Your Honor, is or for any other purpose.
I can take it out. I mean, we don't need, it's saying for the limited purpose of determining the existence or absence of any mitigating factor may not be considered as evidence of aggravation. That's what your biggest concern is, and then we could take out or for any other purpose, which would avoid any possible confusion if you want.
Requests.
Okay.
If you're not going to, if the court is declining to give the instruction the way that we have proposed it.
I am. What else?
That's all with respect to this instruction.
Okay, the next instruction is,
Excuse me, Judge.
sorry.
The sentence that starts additionally, the next one, also has that language at the end of it.
Oh,
Or for
thank
any
you.
other purpose.
You want me to take that out too, Ms. Nelson? The next sentence has the same language at the end, may not be considered as evidence of aggravation or for any other purpose. Okay. Thank you for catching that. All right, the next instruction is the one that starts with every person charged with a crime or convicted of murder in the first degree has the constitutional right not to testify. Do the people have any objections to this instruction?
Oh, yeah.
Ms. Nelson, do you?
Your Honor.
Next is the instruction that talks about the jury having been allowed an opportunity to submit written questions to witnesses throughout the proceedings. Any objection, Mr. Edwards?
No, Your Honor.
Ms. Nelson?
No.
Next is the instruction on note-taking. Any objections, Mr. Edwards?
No, Your Honor.
Ms. Nelson? Next is the instruction about if you have a question once you begin deliberations, and actually starts with once you begin deliberations, if you have a question, and it goes from there. Any objections? Mr. Edwards?
No, Your Honor.
Ms. Nelson?
No, Your Honor.
And then we get to the final instruction, and it's connected to the verdict forms. So, Ms. Nelson, I know that you said you wanted to object to the verdict form, so you can make your objections together if you want.
Yes, sir. Thank you. First, we maintain our objection and argument with respect to the issue of merger.
Okay, and I incorporate by reference my previous rulings and remarks with respect to that issue.
And then also maintain the objection that we made during this charging conference to the language in the third paragraph of that instruction that reads, in that event, the defendant will receive a death sentence on that count, and that sentence will be carried out regardless of the final sentencing verdicts on the remaining counts and regardless of the lack of a unanimous final sentencing verdict on any count. And again, we feel that this issue arises out of the merger error that the court is making, and our concern is the scenario that we discussed earlier, in which inconsistent verdicts are rendered with respect to a single victim.
But in an earlier instruction, you asked me to add the sentence, you must assume that a death sentence will be carried out if you vote to impose it.
Fine, Your Honor. It's just that the way this is phrased, it says the defendant will receive, the sentence will be carried out regardless of the final sentencing verdicts on the remaining counts. And I think that in the event of an inconsistent verdict on one victim, that may not be the case. So.
All right, same position by the people,
Yes, Your Honor.
same ruling, and I incorporate by reference my previous ruling and my previous remarks on that issue. What else?
So, and then the rest of, the remainder of my objections really go to the way that the court has laid out the verdict form.
All right, before you get to that then, let me ask Mr. Edwards, did you have any objections to this final instruction?
No, Your Honor.
All right, and do the people have any objections to the verdict form?
No, Your Honor.
All right, Ms. Nelson, let me hear your objections then with respect to the verdict form.
So we've talked about this a little bit in previous charging conferences, but we don't think it's constitutional or appropriate to separate out a non-unanimous verdict from a unanimous verdict against the death penalty. So that's our first position, that there should be just two sections in the verdict form, which I think is the way that both we and the prosecution structured our proposed verdict forms.
All right, Mr. Orman?
We're okay with that, Your Honor,
With what?
with what Ms. Nelson is suggesting.
Okay, so how do you want that?
So our request would be that I think the first part 1, section 1 of the verdict form that the court has
And the reason I did it
proposed.
this way is because the statute says if the jury is unable to reach a unanimous verdict, then the court should discharge the jury and the court should impose a sentence of life imprisonment without the possibility of parole. So the statute distinguishes between a life sentence imposed by the jury because they're all unanimous in finding that that's the appropriate sentence, and the kind of situation where a life sentence is imposed by the court because the jury could not come to a unanimous decision. The statute distinguishes between those two. That's the legislature that did that. And if that's the case, then it seems to me that I should follow that. That's why I did it this way. And it seems to me that what we're asking the jury is to answer the question, do you unanimously find beyond a reasonable doubt that the appropriate sentence for the defendant is a death sentence? If they say yes, then that's the end of the inquiry. If they say no, there are two possibilities. One is that they're saying no to the question because they all unanimously feel, and it doesn't have to be beyond a reasonable doubt, and the jury is told that in the instructions, that life is the appropriate sentence. They're all unanimous on that, and they're returning a unanimous verdict for life. They're all saying, all 12, we feel that life is the appropriate sentence. So not only are we not unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, we actually are unanimously convinced that the sentence should be life. The other option, or the other possibility, is that they're not unanimous. And that could mean a bunch of different things. That could mean that perhaps some people believe beyond a reasonable doubt that death is the appropriate sentence, but others do not. Or perhaps none of them believe that it's the appropriate sentence, that none of them believe beyond a reasonable doubt that death is the appropriate sentence, but none of them also believe that life is an appropriate sentence. Or perhaps they all are convinced that death is not, they're not convinced beyond a reasonable doubt that death is the appropriate sentence, but they're also not unanimous on life being an appropriate sentence. It could be a whole host of different reasons, but the bottom line is they cannot return a unanimous verdict. And they know because I'm telling them that in that case, I will impose a sentence of life. And so in the end, yes, it's still the same result, but it's a different method of getting to it. And that is that I'm discharging the jury and then I'm the one imposing the sentence. And I'm saying, members of the jury, basically, because you could not reach a unanimous verdict, I'm imposing that sentence, and the sentence is life. So that's why it's structured the way it is, because that's the way I read the statute.
And Your Honor, I guess I don't see that in the statute. What I see in the statute is they have to be unanimous for death, and then if they're, and then it's subsection, let's see, 2D, if the jury's verdict is not unanimous, the jury shall be discharged and the court shall sentence the defendant to life imprisonment. I don't see anything in the statute that talks about a jury unanimously voting for, in favor of a life sentence, and I think it's because under Tennyson and Young and Colorado Constitution, Article 2, Section 20, as well as the Eighth Amendment, the jury's never making an affirmative choice for life. They have to all agree beyond a reasonable doubt that death is the appropriate sentence, and in all other circumstances, regardless of whether they're affirmatively agreeing that life is appropriate or they just disagree that death is appropriate, life is the result. And so the way I read the statute, it's really just, it's those two options. It's one or the other. Either you're unanimous for death or it's life, period. And so that's sort of the foundation of our objection.
Well, the very first sentence of 18-1.3-1201 in subsection 1A is, upon conviction of guilt of a defendant of a Class 1 felony, the trial court shall conduct a separate sentencing hearing to determine whether the defendant should be sentenced to death or life imprisonment. And then he goes on from there. I mean, that's the whole point of a sentencing hearing, right? It's, we haven't been telling the jury in jury selection and thereafter, this is a proceeding for you to determine whether death is the appropriate sentence. We've been saying we're going to have a sentencing hearing so you, members of the jury, can decide what sentence is appropriate. And you have two choices, death or life. Those are the two choices, and that's what we have been instructing them, and that's what we instruct them in the instructions. Now, they can say, we're not unanimously convinced beyond a reasonable doubt that death is the appropriate sentence, and we unanimously believe or feel that life should be the sentence, and that would be a unanimous verdict for a life sentence. Now, I agree that they don't have to have a unanimous verdict for a life sentence, and they will know that too, because it tells them in the instructions. If you're not unanimous, then the court will impose a life sentence. But the subsection later that you quoted, which is subsection 2C or D, it says if the jury's verdict is not unanimous, the jury shall be discharged and the court shall sentence the defendant to life imprisonment. It doesn't say if the jury does not return a unanimous verdict on death. It says if the jury's verdict is not unanimous. It's more general than that. The jury shall be discharged and the court shall sentence the defendant to life imprisonment. So I look at it as three potential possibilities. One, the jury is unanimously convinced beyond a reasonable doubt that the appropriate sentence is death. Two, the jury is not unanimously convinced beyond a reasonable doubt that the appropriate sentence is death. And further, the jury unanimously finds or believes that the appropriate sentence is life. And as to that unanimous finding, it doesn't have to be beyond a reasonable doubt for anyone, and we told them that in the instructions. Or three, they can't reach a unanimous verdict. They can't agree, in which case they tell me that, and I impose a life sentence. So those are the three possibilities that I see.
And I think our concern is, and the way we structured the verdict form in phase 2 was sort of similar to the way I'm proposing we do it now, which is either we do or we don't unanimously agree on the question that's at issue, and whether or not they're unanimous
But I think that question was different. I think there, it was just a one-question proposition. Either they did or they didn't. Here, it's not. This is their final sentencing verdict. This is where they're deciding what sentence to impose. They're not just deciding on the question of death. They're deciding what is the appropriate sentence. Now, there are different rules that apply to each choice. If in order for them to decide that death is the appropriate sentence, it has to be unanimous, and they all have to believe that beyond a reasonable doubt. In order for a life sentence to be imposed, we get to it in two ways, but the only way we get to it by the jury imposing it, if you will, by the jury determining it, is if the jury is unanimous in believing that that is the appropriate sentence. Otherwise, I impose it because they weren't able to come up with a unanimous verdict.
The other concern with having three sections to the verdict form, Your Honor, is that it suggests quite clearly to them that they should be working towards unanimity, and that this third option of returning a non-unanimous verdict is somehow a lesser choice or a lesser option, or only something that they should, only a box they should check if they've done everything else that they can do to try to get to a unanimous verdict. And that's not the way that Tennyson and Young and the Colorado Constitution and the Eighth Amendment contemplate capital sentencing deliberations.
I disagree that he conveys that, and in any event, we have to tell them that. We have to tell them that if they're not unanimous, that the court will impose a life sentence. We have to tell them that elsewhere, and we do tell them that. So what difference does it make? I don't see how the structure itself conveys to them, hey, we want you to reach a unanimous verdict. It does no such thing. It says if you reach a unanimous verdict, here's where you sign. It's one of these two places. If you do not, then here's where you sign.
Well, we maintain our objection to the three-part verdict form. If the court is intent upon keeping that structure, I do have some additional objections and suggestions to make regarding the language of those sections.
I think this is the right way of doing it based on the statute and based on the whole purpose of the sentencing hearing. Do the people want to be heard on that? I am inclined to leave it the way it is because I think this is the appropriate structure.
Your Honor, your legal analysis has convinced me that this is the way it should be.
Okay. Thank you. All right. What language would you like me to change?
So the other issue, and the court alluded to this when it was discussing this earlier, is that with respect to Section 2, the jury could be unanimously convinced beyond a reasonable doubt that death is not the appropriate sentence. But that doesn't mean that they unanimously agree that he should be sentenced to life. It could be that some jurors, they may all reject the death penalty. Some of them may think, by a preponderance of the evidence, I think he should get the death penalty, but I'm not at that reasonable doubt point, therefore I'm not voting for death.
So
the result is a life sentence.
So all 12 of them are saying, we're not voting for death.
Right. But it could be for different reasons. It could be, I think life is appropriate, or it could be, I lean more towards death and life, but I'm not at that reasonable doubt point, right? In which case that person is not agreeing that a life sentence is the appropriate sentence. They're just rejecting the death penalty.
Right, in which case they don't have a unanimous sentencing verdict. And I have to impose a life sentence. There is no unanimous sentencing verdict. I'm asking them, members of the jury, tell me what sentence is appropriate. In your scenario, they don't have a unanimous verdict. They're saying, Judge, we don't have a unanimous sentencing verdict, in which case they understand that it will be a life sentence, but I will impose it.
Well, I think in some senses it is unanimous because they're all unanimously rejecting the death penalty, which is what they're tasked with. I think that the way the verdict form is structured injects this separate and additional piece of it, which is, do we all unanimously agree that life is appropriate? I don't think that's in the statute. I don't think that's required by Tennyson or Young or the Colorado Constitution. In fact, I think it's contrary to those cases.
All right,
so,
I'm sticking to the structure, as I said, for the reasons I've explained. They clearly will know that if they're not unanimous on a life sentence, but they're also not unanimous on believing beyond a reasonable doubt that death is the appropriate sentence, that what will happen is that the result will be a life sentence. It's just that I will impose it. They will know that. So what else?
So
What's the language that you would like me to change?
So in section 2, instead of the way the court has it phrased, we think it should say, we the jury are unanimously convinced beyond a reasonable doubt that death is not the appropriate sentence on this count.
I disagree. I think it has to be the way it appears here, because the question is, are you unanimously convinced beyond a reasonable doubt that the appropriate sentence is death? So they have to answer that question first as a yes or no type question. If they say yes, then they fill out section 1, and then it doesn't matter whether they're unanimous in that finding or only some of them, or why they're not unanimous in that finding. What matters then is, can you return a unanimous sentence of life? And if they can't, then I will impose it. The question is, do you have a unanimous verdict for the court? And if the answer is no, then they will fill out section 3. So that request is denied. What else?
So then our proposal with respect to section 3, or our request, we strongly object to the word cannot, because that suggests very clearly to the jury that they are working towards unanimity, and if they just can't do it, then the result is a life sentence. And so our proposal would be our first proposal would be to say, under section 3, one or more of the jurors are not convinced beyond a reasonable doubt that death is the appropriate sentence on this count.
I don't think that's accurate, so that request is denied. Now, I'm happy to change cannot to we the jury have not reached a unanimous final sentencing verdict on this count, and we the jury understand that as a result, the court will impose a sentence of life imprisonment without the possibility of parole on this count. I'll make that change if you want, but the change that you just requested, I don't think is accurate. So do you prefer have not reached instead of cannot reach?
I would prefer do not have a unanimous final sentencing verdict.
That's fine. Do the people have any objection to that?
I like the way the court originally has it, but I don't have a particular objection.
Okay. All right. Do not have. I will use do not have a unanimous final sentencing verdict on this count. What else? Anything else? And I will change the last instruction accordingly.
So I incorporate the objections and the discussion that we just had concerning the language in the asterisk portions of the verdict form on the second page of the verdict form. There's some language in there that we've previously discussed.
I think I will change cannot, but there I think I'm going to use does not, if the jury does not reach. Otherwise, it's going to sound weird to say if the jury does not have a unanimous final sentencing verdict. I think it sounds better to say does not reach, and I don't think I think it's the word cannot that seems to be of most concern. And I'll do the same thing in the final instruction, but on the actual verdict form, I will change it to we, the jury, do not have a unanimous final sentencing verdict.
That's fine, Your Honor. The other language that I want to maintain my objection to is in the last sentence of that first asterisk paragraph. In the event the jury completes section 1 of this verdict form, the defendant will receive a death sentence on this count, et cetera, et cetera. We think that flows from the merger issue. We maintain that objection.
Same objection with respect to the merger issue and same ruling by me, and so I incorporate by reference my previous rulings and remarks on that issue.
And then in the second asterisk paragraph, again, we maintain the jury does not have to unanimously agree ever that the defendant should be sentenced to life imprisonment without parole, so we maintain and incorporate by reference the objections we made with respect to that issue.
And I incorporate by reference my ruling and remarks with respect to that issue as well.
And then same issues with respect to the third paragraph.
Same ruling with respect to that paragraph. Anything else on behalf of the people with respect to the instructions?
Your Honor.
All right, anything else on behalf of the defense?
I have one, and then Ms. Higgs has one.
Okay.
I just wanted to make sure we made our record clear that we are requesting that the court give our proposed instruction 95, which instructs the jury that they should presume that, have a presumption of life at this phase of the proceedings.
Any response from the people?
Against the law, Your Honor.
I think that is contrary to Colorado law, so I will not give that instruction. And I'm glad that you reminded me, because we had this discussion before, and I incorporate by reference my rulings and remarks with respect to this issue that I have made before. But it is contrary to Colorado law. Are there any other instructions that you want to highlight for me, or any other excerpts of instructions that you think we need to talk about, Ms. Nelson?
We did want to request that at some this goes back to the conversation that we had about the tension between the deliberations and individual reason, moral judgment, that the court includes somewhere some type of language about preventing our concern is with bullying that may go on in the deliberations rooms, and instructing the jury that, I'm sorry, if I may have a moment, this was Ms. Higgs' proposal.
Okay.
Your Honor, if the court looks back at the instruction that we were discussing, this issue.
Which number is your tender instruction? Okay. Okay, I have it in front of me. The one that starts, there's no requirement that you explain or justify to your fellow jurors why your individual reason, moral judgment leads you to a particular decision on account.
So, Your Honor, the reality is in these deliberations, I mean, there is more than one discussion or decision that each juror may make along the way to making their final sentencing choice. So the way this is written, it's just saying that if your decision at the end of it all, if one juror disagrees with all the rest, then that decision has to be respected. But there's no place in here for respective jurors along the way. And I think that that is something that needs to be highlighted for the jurors. And I don't think it's only the situation where if one juror disagrees with all the rest. If some disagree with some others, the reality is that any decisions they make, any values they place, any mitigation they find, those decisions have to be respected by the other jurors along the way. So we suggest some language that says, you know, something along the lines of, if other jurors are trying to force you to do, what is it?
Violence to your conscience.
Violence to your conscience, right? Or trying to force you to change your decisions on any of these issues along the way, that's something you need to instruct the court about.
But that's anti-deliberate. That's telling them you don't have to deliberate. That's, again, I can't interfere with their deliberations. If I say, hey, look, if anybody's trying to change your mind about anything, then you need to let the court know, or you need to make them stop. Well, that's what deliberations are, so they can have discussions about disagreements that they may have. That's why I said before, the court can't interfere with how deliberations are conducted. I mean, I can't say to them, look, you must deliberate, but you must play nice. They have to deliberate, but also I'm telling them there's no requirement that you explain or justify why your individual reason, moral judgment leads you to a particular decision on account. I'm telling them both. On the one hand, I'm saying you don't have to explain yourself or justify why your individual reason, moral judgment leads you to a particular decision. On the other hand, you must deliberate. You can't just go into the deliberations room and say, I'm not talking, I've made up my mind, and this is the way I'm going to vote. And then it's also telling them, hey, once you've deliberated, once you've complied with the duty to deliberate, which the court has instructed you on, then people need to respect your determinations, and the court will respect your determination. And then I remind them, keep in mind that ultimately this is an individual reason moral determination. So I think this is as good as I can, the best I can do, given the conflicting interests that exist, and given the risks and the dangers in having me specify for them how to conduct their deliberations and micromanage their deliberations. I can't do that. That's going to have to be up to them. What I can tell them is the concepts that apply. And as I said before, there is some tension among these concepts, but I've given them to them in the best way that I can, or at least that I think I can. So.
Well, that was our request based on the 5th, 6th, 8th, 14th Amendments to the United States Constitution, as well as the relevant provisions of the Colorado Constitution. In addition, I hate to ask the court to back up, but a thought occurred to me with regard to...
Hold on. Before we move on, do the people have any other thoughts on this particular instruction?
I think Your Honor is bent over backwards to provide the sentiment that counsel's asking for. And I haven't heard a citation to one appellate precedent from anywhere in the United States, not even like a footnote in a dissenting opinion, that says the court is required to give such an instruction.
All right. What else do you have, Ms. Higgs?
Your Honor, it occurs to me after reviewing, again, sentencing hearing Phase 3 instruction, I have it marked as number 20. That was my counting. That starts with, in reaching your sentencing verdicts, you may consider all of the evidence admitted during the proceedings.
Yes.
And when it talks about, the mitigating factors and statutory aggravating factors have been defined for this jury. But this free-floating concept of aggravation, it is something that is new and has not been defined. And because we have decided and agreed that the other non-statutory aggravating factor instruction should not be given. And so I think that this leaves, I think it's inappropriate to give the jury this concept of free-floating aggravation, and I think that's why it's more...
Wait, I'm not sure which instruction you're at. Are you at the one that says, in reaching your sentencing verdicts, you may consider all of the evidence admitted during the proceedings?
Yes.
Including evidence of mitigating factors, evidence of the proven statutory aggravating factors, and victim impact evidence. That one?
Right.
We took out evidence of non-statutory aggravating circumstances.
Right.
Well, you think they should not be allowed to consider aggravating factors?
No, if you go to the next sentence...
Oh, okay.
The next two sentences end with this concept of, the evidence admitted during Phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor, and then it says the phrase may not be considered as evidence of aggravation.
That was at Ms. Nelson's request. Do you want me to take that out?
No. Just change that. It's more consistent with the law and the other instructions that they have previously been given to state that it may not be considered as a reason to impose impose a death sentence or the death penalty, because just aggravation on its own is not something that is been presented or is relevant or is defined in their decision-making.
Right, do the people have a position on that?
I think the way that sentence is written, there's not a problem.
Well, it comes up twice. She's saying, instead of saying as evidence of aggravation, we should say as evidence in support of a death sentence.
I remember somewhere, I don't remember reading it in these instructions, but maybe it was in the introductions where it said that non-statutory aggravation is reasons to impose a death penalty?
We took that out because there was a disagreement, and so we ended up taking that out. So we have not talked to them about non-statutory aggravating circumstances. So it may make sense to just change that. It's the same concept anyway, There is no mention of aggravation anywhere else other than to talk about statutory aggravating factors. And the reality is that evidence that was admitted in Phase 2 for the limited purpose of determining the existence or absence of any mitigating factor, if it cannot be considered for evidence of aggravation, what we're saying is it can't be considered in support of a death sentence, right? So it seems like it's saying the same thing, it's just using different language.
Your Honor, it seems to me that what this is a limiting instruction. Maybe what we do is take out the first sentence and then well, there's problems with the first sentence, but so instead of aggravation, they want to say reasons to impose a death sentence?
Or as evidence in support of a death sentence.
That's fine.
Okay, I think it's fine too.
And we need to also put that language in that first sentence.
No. Yeah, it's the second and third. The first sentence is fine. We've taken out non-statutory aggravating circumstances there. We have proven statutory aggravating factors there, but
The
that's
problem with
fine.
that, Judge, is that then what you're telling the jury in the first sentence is all they can consider is the proven statutory aggravating factors.
I see.
It says including. These are all the evidence.
Well,
including evidence.
but it made more sense before because we had indicated or also listed non-statutory aggravating circumstances. If you want, I can just stop at proceedings and leave the rest of it out. I mean, I don't have to specify including, because this could be understood as meaning that it's a complete list.
I think that makes sense, Your Honor.
Is that okay with the people as well?
Yes, Your Honor.
Okay, that's what I'll do. All right, thank you for catching that. All right, is there anything else before we adjourn?
To reserve the right to take a second look at that last instruction in the verdict form tomorrow morning,
Okay, all right,
make additional arguments if I need to.
all right, but no other portions of your tender instructions that we need to talk about or that you want to talk about at this time, right?
Not at this time, Your Honor, but I would like a final opportunity in the morning.
That's fine.
If something jogs my memory in the evening.
That's fine. Ms. Tish McGuire, do you have something?
Just briefly, Your Honor, I wanted to know if the court planned on taking a break after jury instructions are read tomorrow?
Yes,
Okay, so there will be a break between jury instructions and closing.
yes,
Thank you.
yes. Okay, and remember that you only get a rebuttal if there is a closing before yours. So, for example, if the defense decides that they don't want to make a closing argument, the people don't get a rebuttal. If the people don't do a rebuttal, the defense doesn't get a rebuttal, okay? All right, have a good evening. Oh, how about 9? I think we're pretty much done. I don't think it's going to take us a lot of work. Is 9 o'clock okay with everyone?
I think that's safer in case something does come up.
Okay, all right, 9 o'clock. All right, thanks, everyone. The court will be in recess.